Okay, welcome everybody to our webinar on managing conflicts of interest. I hope you can hear me. My name is Catherine Elverston. I am the Registrar here at the Immigration Advisors Authority. So we have 350 people registered for this webinar today. I can just see the numbers creeping up, so people are joining us as we speak. So on the webinar with me today, I have Catherine Rosie, who is our Senior Technical Advisor, and she will be assisting me with answering some of your questions. So this webinar is on managing conflicts of interest, and I'm going to talk through our requirements, or your requirements as a licensed immigration advisor. And then we anticipate that people have got lots of examples that they want to share in terms of what is a conflict of interest or questions around what are conflicts of interest. So we'll have a bit of a brainstorm session and share some of the examples of common conflicts of interest that licensed advisors need to deal with. And then we will have a session at the end for any other general questions that you might have. So I'll start by talking about what is a conflict of interest, and I'm going to take you to our toolkit, which is on our website. So this is under for advisors tools, the Code of Conduct Toolkit, professional responsibilities, and we are looking here at conflicts of interest. So I think the important place to start is that as a licensed immigration advisor, you have a duty to have a relationship of confidence and trust with your client and to give objective advice. So that's the starting point. The starting point is that you are there to provide a professional, objective service in regards to immigration advice to your client. Now, we realise the reality is that sometimes you may offer other services, or there may be other people involved. It may not simply be a relationship between you and your client. There may be other people and other interests involved in that particular situation. So just to give some common examples as a starting point that we see, there is recruitment and employment. So for example, you may also be recruiting a recruitment agent, you may be dealing with a recruitment agent, or you may be assisting someone in terms of getting a job, as well as the immigration advice. We see it in the education context, so often licensed immigration advisors are placing people in schools and getting a commission from the school for that placement. Also, we see family connections, so often licensed advisors may be dealing with multiple different people within a family or in a family context, or you may even consider providing advice to a family member. So all of these things, I guess, are common examples of a conflict of interest that may arise in your situation. So when we talk about a conflict of interest, and you can see this here in our toolkit, we start by talking about the principle of good faith and the concept of undivided loyalty. So that is you as an advisor owing to your client a duty to act in their best interests, free from any other competing loyalties to anyone else or to yourself. So that means that if you've got some other interest which may influence you in your advice or your thinking or your decision making about that client, then that's a potential conflict of interest. So a conflict of interest arises when an advisor's own interests or the interests of another client of the advisor may influence the advisor's judgment or actions towards a client. It's important to note that a conflict may arise between the advisor and the client, or between two different clients of the advisor, and the advisor needs to manage both of those contexts. So that is just, I guess, a general introduction to what a conflict of interest is, and it may arise in lots of different situations that you face as an immigration advisor. And you need to consider and think about, do I have any other interests that are going on here in relation to this client? So the message that we want to give you today is that managing conflicts of interest is actually very simple. It's not complex, and so we're going to talk through how you manage a conflict of interest. And it really is as simple as 1, 2, 3. We've got 3 important clauses in our code which relate to conflicts of interest. There are a couple of others I'll mention as well. But the starting point is disclosure. So under clause 5 of the Code of Conduct, which you've got here on the screen, when a licensed advisor is aware that there is a potential or actual conflict of interest relating to the client, including the existence of any financial or non-financial benefit the advisor will receive as a result of the relationship with the client, the advisor must disclose the potential or actual conflict to the client in writing. So clause 5 is about disclosure. If there is a potential or an actual conflict of interest relating to a client that you're about to take on, you need to disclose that in writing to your client. So it does need to be in your written agreement. In all cases, it needs to be in your written agreement. You may have disclosed it prior to the written agreement, or it may arise after the written agreement's been signed, in which case you'd need to make an amendment or ensure that it's clearly documented in writing. But the first step is disclosure. So what do you need to disclose? So you need to be as transparent as possible. You need to explain as fully as possible what you believe the actual or potential conflict of interest is to your client. And that needs to be in writing. So that is the first step. Clause 19L of the Code of Conduct, which relates to written agreements, and I'll just flick to that now. This is really a repetition of clause 5, but it just makes it crystal clear in the written agreement section that you need to have recorded in your written agreement any potential or actual conflict of interest relating to the client, including the existence of any financial or non-financial benefit the advisor will receive as a result of the relationship with the client. So it's quite clear it needs to be in writing up front. So that's the first step. The second step is that the client needs to consent to it. So this is under clause 6, where a licensed immigration advisor is aware that there is a potential or actual conflict of interest relating to the client. The advisor may only represent or continue to represent the client where the client gives written consent. So first up, you disclose it in writing. Second, you get consent for you to continue or to represent that client. So this can take place in the written agreement with the disclosure in the written agreement and the consent being the signing of the written agreement. If it happens after the written agreement has been signed already, then it needs to be documented in writing, and there needs to be that consent of the client. So the disclosure needs to be honest, it needs to be transparent, and the consent needs to be genuine. So there genuinely needs to be an opportunity for the client to decide that they don't want to use your services in light of this conflict of interest. So these are the first 2 steps, and they are really important, as I'll talk to in a little while. But what I'm just going to do now is pause and get some feedback from you in terms of what are common conflicts of interest that you're encountering in your day-to-day practice. And that you are managing by disclosing and getting consent. If there are questions that you have relating to whether something is a conflict of interest or not, then please feel free to type these in now. So it's really important if you are sending us in questions that you make your questions or your comments as clear as possible. We have about 250 people in the webinar at the moment, so there will be a large number coming through, and it's really helpful if you can make your comments or your questions as clear as possible. So I'll just pause for a moment, and Catherine, as you start getting some examples coming in, then you can just start reading them out. As I've mentioned already, we do see examples in the employment space, the recruitment space, the education space, and in family connections, also business potentially, which we'll talk to a little bit later on. But sometimes people are involved in business ventures with clients, which is very clearly a conflict of interest.
Can we have a question here regarding receiving commissions from private training education providers, sorry?
Yes.
And whether that would be...
Okay, so yeah, so that's really clearly an example of a conflict of interest. So that's quite clear in clause 5. If you are receiving a financial benefit as a result of the relationship with a client, so as a result of you placing a client in an education institution, that's clearly a conflict of interest, so it needs to be disclosed. So with any students that you're assisting, it needs to be in your written agreement up front if you're going to be getting a commission from the school. You also need to consider the objectivity of your advice. If you are limited in the schools that you are placing people in as a result of commissions or anything or any arrangements you have with particular schools, you need to be very clear about that with your client, and that you're not giving them options to place them in any institution, for example, if that's not the services that you offer.
Okay, I have another one here. If I'm hiring a person and applying for the work visa for this person without fee, is there a conflict of interest?
Yes, that's a very clear example of a conflict of interest. So you're both employing someone, so you've got an interest in employing them, and you are also providing them with an immigration service. So it's really important that as a licensed immigration advisor, whether or not you're charging fees for your clients, you're still required to adhere to all of the clauses in the Code of Conduct. So it's really important that you manage the conflict of interest in exactly the same way as you would as if you were taking a fee. So you need to disclose to the client that you have an interest in employing them, and you need to get their consent to go ahead with assisting with the immigration services. I will come to clause 7 after we've just had this little bit of brainstorm, but that may be an example of a situation where you choose not to represent the client in the immigration matter, because the conflict is quite significant there, and it may be preferable not to, because in that kind of situation. So we're going to talk about clause 7 in a little while, but I'd just like to get some examples out in terms of the kind of common conflicts of interest that you might be dealing with on a day-to-day basis, that particularly those that you consider that you can manage by declaring it and then getting the client's consent. And I think the Education Commission is an example there. Is anything else coming in, Catherine?
Yep, quite a few here. So someone has asked if a client discloses some information to me, which I know needs to be disclosed to INZ, but the client does not want the information passed to INZ, is this a conflict of interest?
So that's something that really you want to manage under clause 30, get my clause right. Just let me reach for the code. It is clause 31 of the code. So I'm not going to go into that in any detail in this webinar, because we want to focus on conflicts of interest, but there is a process that you need to go through if you've got information that you feel is material that you need to disclose to INZ and your client hasn't given you consent to do that. So have a look at clause 31 of the code, and you'd manage it under those provisions there.
Someone has asked us, there's been a few people ask, If they need to disclose the exact amount of a commission, or if they only need to disclose in the service agreement that they're receiving a commission.
Okay, so there isn't a requirement specifically to disclose the exact amount of the commission. So you can see there that clause 5 refers to the existence of the financial benefit. So you need to disclose that you're getting a commission. We encourage you to be as transparent as possible in the circumstances. We encourage transparency, but there isn't a specific requirement to disclose the actual amount. So if you can be as transparent as possible, but you don't have an actual obligation to disclose the actual amount of the commission.
Someone has asked, sorry, I've lost it here. With medicals, when the employer is paying and the client has a medical condition and you cannot disclose it to the employer, is that a conflict of interest?
Sorry, can you repeat that question?
If the employer is paying for the medicals and the client has a medical condition that you cannot disclose to the employer, is that a conflict of interest?
Yeah, well, I think the example is a conflict of interest. So if you have an arrangement with the employer, and you have an agreement with the employer is paying your fees, and you are managing visa applications for potential workers for that employer, that's a conflict of interest. So it's important that that is managed in as per clause 5 and clause 6 in your agreements with the both the employer and the actual client themselves. So yes, it is a conflict of interest, and yes, it needs to be managed in the way that's set out in clause 5 and clause 6. In terms of confidentiality, that's a whole other topic, but you need to manage your confidentiality requirements in that situation as well, and you need to get the appropriate agreements up front to ensure that you can manage that relationship. If there is a situation where you would require that you need to breach confidentiality in order to be in a client relationship with somebody, then you can't represent that client, and we're going to get to that with clause 7, which I'll come to shortly. So I think that's a really good example of where you need to manage your conflicts of interest up front in your agreements, and you also need to consider your confidentiality requirements.
Okay, we have another one here. Someone's asked, what if you were working for an education provider as an international support officer, as well as representing students when necessary as a licensed immigration advisor? Would this be considered a conflict of interest if you do not have sales, marketing duties and do not have targets? Okay, so look, it's a little bit unclear from the example, but if you've got different roles working for an organisation, if you're working for an organisation in one role and you're a licensed advisor and you're working in another role as well, potentially there is a conflict there. I'm just a little bit unclear on the exact situation that you're talking about. But I think it's really important that that if you do have different roles, that you're really quite clear on those, that you're quite clear on where there is crossover or where there isn't, and that and that you manage those conflicts of interest if there is a conflict of interest. So if you're doing two different kinds of jobs for an education provider, it sounds like there might be a conflict of interest there, but it's a little bit tricky to understand the complete situation with just a snippet. But it sounds like potentially there is a conflict that needs to be managed there. Do you have anything to add to that, Catherine? No. We have quite a fean questions regarding family members in situations when there's no charge. What is the best way to manage that relationship?
Okay, so where there are you are representing family members, and I'm probably talking about here not just a one family unit, but if you've got different clients who are part of an extended family, it's really important that it's clearly a conflict of interest if you've got different family members. So you do need to manage it. You do need to. You will need to get the required consents up front. So from your existing client, if you've got an existing client and you are considering taking on a new client that is part of that person's family, then you need to get the consent of the existing client to disclose that conflict of interest to the potential new client. If you don't get that consent, then you wouldn't be able to take on the new client. So it's important that you are able to disclose to new clients the existence of conflicts of interest. If you can't disclose those because it would breach confidentiality, then you can't act for the new client. So it's really quite straightforward. You need to be able to disclose your conflict of interest under Clause 5 to get the consent. And if that involves you declaring that you've got an existing relationship with someone, then you're going to need to have their consent to disclose that. Any other questions, or any other questions before I move on? Or common conflicts of interest that we're seeing coming in?
Well, there's a lot. There's a lot regarding family, but I think you've largely covered that. Otherwise, there's one here. Sometimes I work for an employer and sometimes an employee at the same time with that, and split the fee between them. Can this be a conflict?
Sorry, you just cut out in the middle of that. So can you repeat that question?
Sometimes I work for an employee and an employer at the same time, and I split my fee between the two. Can this be a conflict?
Yeah, potentially it could. So yeah, look, I think the reality is in a webinar like this, we can't go into a whole lot of detail with situations, so probably need a little bit more information to understand that situation. But I think what you need to think about at a high level, it's do I have another interest here? So I have a client, in a pure kind of situation, I would just be providing objective immigration advice to this client, and there wouldn't be any other influences going on. So what you need to stop and think about is, are there any other influences here? Am I getting paid by an education provider as well? Do I have relationships with other family members or friends or people? Is there a business arrangement going on here? So anything where you're potentially influenced because there might be some financial gain, or there might just be an existing relationship there, anything that's a potential influence is a potential conflict of interest. And what you need to do is you need to manage that by being upfront, by declaring it and getting the consent to go ahead. And you need to be as transparent as possible as you can in the situation. And those are the first two steps. And we're not going to be able to, there isn't a specific rule for every little, every different kind of scenario. But it's important that you think about this. And you think, where is there a potential conflict of interest? And if you think there's a potential conflict of interest, then you declare it and you get the consent to proceed. So those are the first two steps. And the second step, so I'll just go on. There'll be time for further questions shortly. So the step 3, which may actually be step 1, comes under clause 7. So there are going to be times when it isn't enough to declare your conflict and to get consent to go ahead. There are going to be times when you as a licensed advisor need to make a judgment call that it's not appropriate for you to represent this person. So under clause 7, you must not in any circumstances represent or continue to represent the client where you're aware that there is an actual conflict of interest that means that your objectivity or relationship of confidence and trust between you and the client would be compromised, or where you would breach the confidentiality of a client. So I've already talked a little bit about the confidentiality aspect. So if you need to breach an existing client's confidentiality in order to declare a conflict of interest and you don't have their consent to do that, then you can't act for them. Or if there's some other confidentiality that you would need to breach in order to represent a new client, then you simply just cannot enter into that new relationship. If, in terms of A, whether your objectivity or relationship of confidence and trust would be compromised, that's a judgment call that you need to make in the situation. And you really need to consider, can I be objective? Can I truly be objective here? So let's take, for example, an example of you both employing a person and representing them in the immigration matters. Is your desire to employ them so great that you can't provide them with objective immigration advice? Is there something that is going on, perhaps in a business relationship, that means that if they knew about this, well, maybe they really wouldn't consider that I was trustworthy or could provide immigration advice, could provide objective immigration advice? Now, these are just examples. This isn't the limit, but you need to really make that judgment call yourself. Can I be truly objective? Can I be trustworthy? You know, am I trustworthy in this situation? So, if you can't, then you can't continue to represent someone, or you can't enter into a new relationship with them. So we do talk about here in the toolkit that if this sort of situation arises, then you've got a couple of options. You can find a way to manage or remove the conflict so the situation doesn't arise. So that might be your first port of call. And if you can't do that, or you choose not to do that, then you can't act or continue to act for the client. So this is in both situations, if there is something that's impacting on your objectivity or your ability to maintain your confidentiality requirements, then you can't continue to act for someone. So the kinds of situations where you might see this arising. Now, we don't have a decision from the tribunal on this particular clause at this point in time. We do have potential complaints relating to this, but I think it's important to be aware that if you have got conflicts of interest and you don't declare them, or you choose not to, or you choose to continue to represent someone where there's you know, a real genuine conflict there, then there's a real risk for you as an advisor. And the risk is that you may firstly, you may not be honest with your client. You may not be being honest with your client by not declaring the conflict or not being honest about it. Or if you genuinely can't give objective advice, then you may not be being honest to your client in terms of the immigration options. And these things are actually really serious. So we do have a decision which is referenced here in our toolkit, which relates to a conflict of interest where the advisor was attempting to employ the person who she was assisting with a residence visa application. So the client needed a job offer in order to get residence. The advisor gave the client a job offer at her own business, and Immigration New Zealand found that the job offer was not genuine, and that it wasn't. The business wasn't able to support that job. And the finding in this particular case was not a breach of the conflict of interest clauses, it was a finding of dishonesty. So, and the advisor in this case did lose their licence, it was cancelled. So it can be very serious if you're not able to give objective advice, or you're not honest about the conflict of interest that's going on. So it is important to step back and think, is this the best kind of relationship or client for me to take on in the circumstances? And particularly where you might have, and it doesn't arise often, but from time to time we see examples of advisors who enter into business arrangements with a client, or maybe the business arrangements came first, but they're in some sort of business venture with a client, and those sort of arrangements do get very complex, and there is quite a bit of risk. And if the relationship breaks down for any reason, and then it appears that the conflict of interest hasn't been managed properly, it can be quite serious for a licensed advisor. So those really are the comments that we as the authority have on conflicts of interest. You need to think about conflicts of interest that arise for you, and you need to manage them. And the first two steps are disclosing the conflict in writing and getting agreement to go ahead under clause 5 and clause 6. But you also need to step back and think about, is this the best relationship for me to be in? Am I better not to provide immigration services to this person because we've got another relationship going on or something else going on? So it really is simple and straightforward. I know that sometimes people find the examples quite complex, but you really need to think about, is there something else? Are there competing influences or interests here in this relationship? And if so, you need to manage it as a conflict of interest. So I'm going to pause there, and we can take more questions and comments that you might have. It would be great if people had some examples of conflicts of interest that they consider fall within clause 7. So examples that they think that they wouldn't go ahead in a relationship with a client for immigration services. If you've got any of those examples, please send them through. And if you've got any other questions or examples, we'd love to hear them. So over to you, Catherine.
Yeah. We have a question here. Someone's asked if they would be having a conflict of interest if they're submitting a visa as for a client, whilst also being their sponsor for that visa.
Yeah, so that's a great example of a conflict of interest. It's a great example. Definitely a conflict of interest, no question. You're being you're sponsoring that person, and you're representing them as a licensed immigration advisor. There is a clear conflict there. It needs to be managed.
And someone's also asked,
so, yeah, great example.
If they are representing spouses, but for different kinds of visa. For example, a student visa for one and a work visa or tourist visa for the other spouse, would that be a conflict of interest?
Well, I think that it may depend on how you enter into the relationship with the two people. Are you entering into separate agreements with them? Are you entering into one agreement? Obviously, you need to manage the expectations with those two clients around confidentiality, and that needs to be. You need to consider that right up front in terms of how you're going to deal with that and get the appropriate consents. And if they decide to go their separate ways during the course of your services, how you're going to manage that. And if you're going to continue to manage both of them, then that may be a conflict of interest. Potentially, yes. I think that clearly there's a conflict if the two people decide to go their own ways and you are continuing to manage both parties. If they're dealing with you essentially as one client and you're managing them together, then you need to set up your confidentiality agreements appropriately. But if they're essentially in one agreement with you and you're dealing with them together, potentially you don't need to disclose it as a conflict of interest.
Okay, someone's asked about hiring a person and applying for a visa for the same person. Our goals are ultimately the same. My interest as an employer is to hire this person, so the work visa is required. As an advisor serving this client, my goal is to help them get the visa. How is this a conflict?
So you're not just providing immigration services to that client. You have an interest as an employer. So you've got different interests. You've got an interest as an employer to hire that person, and you've got an interest to provide them with immigration services, and those are different. Those are different interests. So I guess the focus there is more on the difference of the interests and perhaps less on what you might consider to be a conflict. There doesn't need to be a conflict in the nature of something, a disagreement, I guess. But if you've got competing interests, so employment is one, immigration is another, you're not simply providing immigration services free from any other interests or loyalties, as we say, then that's considered to be a conflict of interest, and that is something that you need to manage. So you do have interests that are different, that are in addition to your interests with in terms of providing immigration services. So it really is important that that is managed. And you also need to think about what happens if things go wrong. So it might not appear to be a conflict of interest when things just go according to the book, but the problem is when things go wrong. And I think that if it's really recommend that you read this decision, this Chase Seymour decision here, which is exactly that situation. And things went wrong, and that's where you've got a good example of where it's a conflict of interest that needs to be managed. But good question.
Yep. Someone's asked what the difference between an actual conflict of interest versus a potential conflict of interest would be.
Right. Well, I mean, I think maybe the example that we've just had is or possibly any of the examples that we've been talking about. The potential is there for your advice to be not objective. The potential is there for there to be a competing call on your priorities or the advice that you give, and it's not necessarily always going to eventuate into something that I guess is really I guess detrimental to the client. So I'm not quite sure that there's always a bright line, but I think for the purposes of what you're considering, you need to consider whether there is a potential for my loyalties to be divided to this with this client. Now, I know that in regards to Clause 7, we talk about an actual conflict of interest, and I think that's where you really need to be considering. I mean, I think the confidentiality is a bright line. If you're going to breach confidentiality of any of your clients, then you can't act. That's an actual conflict. And if you really can't provide objective advice, then that is also a conflict. So if you're so caught up in a business venture or in some other business interest that you're steering your client down that line, then that's clearly an actual conflict of interest. But there will be other examples.
Someone has asked if you were employed as an immigration advisor in an employee capacity to a corporate company assisting with incoming international employees, is there a conflict of interest?
Look, I know that we have a number of advisors who work for large organisations, and their jobs are to assist with the immigration matters of incoming employees for those organisations. And I think that I think it should be managed as a conflict of interest, and you know, it's a very simple thing to do. It's a simple disclosure in all your written agreements that you are employed by that organisation for that purpose. I mean, I don't know what the situation would be in those circumstances if the client came to you at some point during the process and said, "Oh, I actually don't want to work for these people, I want to work for someone else. Can you assist me with that?" And what you would do in those situations. But you need, I consider that it is at least a potential conflict of interest, and that you need to be declaring upfront in your written agreements that you are working for this organisation for the purpose of assisting, you know, work visas or whatever type of visas they are for that organisation, and get the and that's clear to the client, and they understand that, and that they're consenting to that. And I think that that's an appropriate way to manage that.
Someone here has asked, or given the example that some student visa consultants place students where commissions are higher, for example, with private institutions, when compared to government institutions and the commissions are lower. Is this a conflict of interest?
So I think, you know, it's really about providing objective advice, and I think that you need to consider what services you're providing in this sort of situation, and what is the advice that you're giving to the client, and what's their understanding of the advice that you're giving to them. Now, if you are recommending that you are sending that students go to particular institutions because you get a commission from them, then that needs to be disclosed very clearly to the client. It's definitely a conflict of interest. And you know, if you consider that there are alternative courses that a student could do at another institution for a lower price that you're not going to get a commission for, then, you know, it may be your duty to provide, in providing objective advice, that you inform your clients of that. So I think that's something that it's really important that you're not giving the impression to a client that this is the only option for them if you're getting a financial gain from that, and it's actually costing the client more than it need to. So that's a kind of example that, you know, this code is designed to protect clients from that kind of thing happening.
Okay, I have an example question here regarding if your client did some housework for you or did some maintenance, is this a conflict of interest?
Yes, absolutely. So you need to be really careful in these kinds of situations, and if you're entering into another kind of arrangement with a client, other than providing immigration advice, it's a conflict of interest. So if you're employing somebody, it's a conflict of interest, and it needs to be managed. So there's all sorts of things that could go wrong in a situation like that. And as a licensed immigration advisor, you need to be professional, and you need to manage those sorts of things in a professional way. And it's the same with family. So it's really important that that every client, whether they're family or whoever they are, you are following the clauses in the code and you're managing it in a professional way.
I have an example here from someone who stated that they had a client who applied for a permanent residence visa on his own and had a conviction of assault on his ex-wife. The advisor is family friends of the ex-wife, and when they found out, they decided not to go through with helping him respond to the deportation order, as they thought it was too close and a conflict of interest, and informed him. When discussing this with his supervisor, the supervisor thought he could actually represent the client, as the relationship with the ex-wife was not actually involved in responding to the deportation order. What do you think?
Look, I really don't think I can provide comment on that specific situation in this context. I need to understand the details more thoroughly. When family members are involved, you need to think about it and you need to manage it. And I think that if you're ever uncomfortable in representing somebody because of a situation, be it like that or any other kind of conflict or potential conflict of interest, it is reasonable to decide that you don't wish to represent that person. That is a fair response, and if you feel that you need to do that in order to maintain your own integrity, or to maintain your integrity with another client, then that is a legitimate thing to do. And it's better to err on the side of caution and not represent somebody where you're concerned than be in a situation where where things could go wrong, and that you're either not able to provide objective advice, or that you're going to breach confidentiality. Anything else come through?
Nothing that we haven't already answered.
Okay, so look, I think those are all really good examples that you've raised. I think generally with the comments or examples that you have raised, my response has been it's a conflict of interest. So I think if you're concerned that there's a potential conflict of interest, then you manage it as such. There is no harm in declaring it to your client and getting their consent to proceed. It's important that you do that where there are potential conflicts of interest. So it is a straightforward process. You may even have standard clauses in your written agreement if this is something that comes up commonly for you, such as if you work with employers or recruiters on a regular basis, then it can be a standard clause in your contracts. If you are receiving a commission on a regular basis, then it can be a standard clause in your contract, and you are declaring that up front and you are getting their consent in the written agreement. So it isn't onerous, it isn't difficult. You simply need to declare it and get their consent to go ahead. Just a reminder that if the situation arises after you've entered into a written agreement, you need to document that in writing, both the disclosure and the consent from the client. So it's very simple, very straightforward. It does not need to be onerous. You just need to be as transparent as possible, disclose it to the client and get their consent. And then you need to stop and think, well, when you're entering into any relationship, you need to stop and think, is this an appropriate relationship for me to be in? Can I be objective? Can I maintain my confidentiality requirements? Is there consent that I need to get up front before I enter into this agreement? So those are the kinds of questions that you need to ask, and you need to stop and think, is this really an appropriate client for me to take on given the situation? So really encourage you to stop and think, and make sure that you are managing conflicts of interest. In most situations, it's going to be sufficient to disclose it and to get their consent. And then there'll be some situations where you really need to say, no, actually, in this situation, I'm not going to take on this particular client. There are lots of other clients out there for me, and I may even suggest someone else that they can go to. I do urge caution if you are entering into business arrangements with clients. Those situations can get very complex, and you need to manage those really carefully. And that may be an example where you simply can't represent them for the immigration matters if you're also entering into other kinds of business ventures with them. Before I finish, are there any other last minute questions that have come in, Catherine, or comments?
Nothing new that we haven't covered already.
Yep. Okay, great. So this does count towards your CPD, and what I encourage you to do now is to take 5 minutes to stop and think about the webinar, to think about what's the key takeaways for you, note them down in your CPD record, and yeah, just think about anything that you're going to change. Maybe it's a clause in your code of conduct, or maybe it's just a reminder to yourself in certain situations that you need to manage the conflicts of interest. So I encourage you just to take a few minutes now to stop and think, and to make a note in your CPD record of your reflections from this. And yeah, thank you all very much for joining us today. You will get a record of attendance that we'll email out to you tomorrow, and welcome your feedback. If you've got any feedback, please send it through. We've got another webinar in November, which is on client communication, and I'm sure many of you are planning to join us for that. So yeah, thank you very much, and have a great day. Cheers.